Next point is Section 126 of the Transfer of Property Act 1882. That means suspended or revoke the gift. The donor and the donee may agree that on the happening of any specified event which does not depend on the will of the donor, a gift shall be suspended or revoked, but a gift which the parties agree shall be revocable. But a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or in the part as the case may be. That means this section explains how a gift can be revoked. The general rule is a gift cannot be revoked, but Section 126 provides that there are exceptions that on the happening of any specified event, those are beyond the control of the parties, then a gift could be suspended or revoked, and both donor and donee must give their assent regarding this specified event. That means nothing contained in this section shall be deemed to affect the rights of the transferees for consideration without notice or notification or assent. First illustration is A gives a field to B, reserving to himself with B's assent the right to take back the field in case B and his descendants die before A. B dies without descendants in A's lifetime. A may take back the field. That means a field or land, a gifted field or land to B, and B gave his assent. That gift can be reserved to A. Regarding the happening of any specified event, those are beyond the control of the parties. Here it is B and his descendants' death before A's lifetime, and obviously it is such event that it is beyond the control of the parties. On the other hand, if A killed B or his descendants to return back to the field, then that will not be revoked or that will not be suspended. If it happens before A's lifetime, and A may take the field according to their assent, and that is A and B's assent, when B and his descendants death before A's without the control of the A. Without the control of the A. Please remember that. So gift can be revoked after the donee's death. That means B's or his descendants' death. The gift will be returned back to A, which is beyond the control of A. The second illustration is A gives, for example, A gives 1 lakh taka to B, reserving to himself with B's assent the right to take back at pleasure taka 10,000 out of the 1 lakh. The gift holds goods as to taka 90,000 but is void as to taka 10,000, which continue to belong to A. In this illustration, A and B, that means donor and donee, both agreed or give assent that the gift holds goods as to taka 90,000, and taka 10,000 out of 1 lakh will go back to A for A's pleasure. That means 10,000 taka is not a property property which A gives to B. And therefore 90,000 taka will consider as a gift, and the 10,000 taka will not be considered as a gift. And that is suspended because it is such condition or event that is in the control of the donor, and even if donee also gives his assent that yes, the right to take back at pleasure 10,000 taka. Next point is will. A will or testament is a legal document that expresses a person's testator wishes as to how their property estate is to be distributed after their death, and as to which person executor is to manage the property until its final distribution. That means testamentary documents are those which are desired by their maker to be effected only upon and after their death and not before. For this purpose, testator competency or competent according to the Contract Act to according to the Contract Act can make a will, and will be attested by at least two witnesses. Each of the witnesses must see the testator signing the will in the presence and have received an acknowledgement from the testator of having so signed it. So the testator must be competent, and there must be two witnesses, at least two witnesses, and each of the witnesses must see the testator signing the will in his presence, or have received an acknowledgement from the testator of having so signed the will. A testator may execute his will by signature or by affixing thumb impression or mark, and a will must be made by a testator, and a will must be made by a testator is capable of being revoked by him during his lifetime. That means will can be revoked any time during testator's lifetime. Therefore, you must remember few conditions. Number one, will or testamentary documents effective only after the death of the testator. Number two, transferee gets the property as soon as its legal formalities are completed as legal consequence after the death of the testator. Number three, testator can give only 1/3 of the total property, cannot be whole property. Number four, will depends on the desire of the testator, and it is not necessary to take assent of the testatee. Number five, testatee must be alive at the time of the death of the testator. That means testator can be, that means the will be effective or will effect only after the death of the testator, but testatee must alive at that time. Testatee must alive at that time. Now the point is deed of will. Now the question is, how can we write a deed of will? We already saw the rules and formalities for writing a deed. You can write the deed of will in the same way. But for this purpose, please remember few things in your mind when you will prepare the deed of will. That is, number one, parties, testator and testatee, name, son's name, father's name, mother's name, occupation, NID. Number two, details of execution, when it is started, ended, when null and void or revoked. Number three, consent, which is one of the important part of any kind of contract. Deed of will is a valid contract, therefore testator must clearly mention that he did this deed of will under free consent. That means without influence, and there was no undue influence. He also confirmed in his deed that at the time of making deed he was mentally and physically fit as his self-declaration, and it is very important part for a will, self-declaration, that he is a competent person according to the Contract Act. That means he is a manager, he is a sound-minded and not disqualified by law. Number four, if there is any beneficiary, then you need to put detail of the natural and artificial person. You already know who is a natural and artificial person, and for artificial person, that person must have legal entity, must have. Otherwise, it is not possible to include him as a beneficiary. Number five, details and description of the property. Only those property which have got absolute ownership by the testator and have transferred and must be 1/3 of immovable or movable property. And for this purpose you have to remember, if that is immovable property, schedule of the property must be given in the deed of will, and if that is movable property, then you have to put what types of movable property, if that is money, where it is, which branch, which bank. So you have to put the details and description of the property. And last one is signature of the testator in front of the witnesses. Obviously at least 2 witnesses, and 2 witnesses must be present there. And this deed of will execute after the death of the testator, and he can revoke or he can change any time during his lifetime. And please prepare a deed of will for your further development, and and for your practice also. Thank you. That's all for today. Hopefully very soon we will meet by Google Classroom as consultation hour. If you have any questions, please feel free to ask me on Google Classroom as consultation hour.